A simple plea deal, or something much darker hiding behind it? Because what this man admitted in court might not be as minor as it sounds.
I have Sioux.
Oh, it's what?
Sioux. Native American Sioux.
Oh, it looks like a T.
Yeah.
Oh, and the X. Okay, so you're Native American?
Yes.
Amazing, great. Okay, it's just hard to see.
It is.
Because I was like, what does it say, stout? You don't use stout all the way, or beer?
I was thinking beer when you said it. I was like, I don't remember that tattoo.
All right, I apologize.
You're
but,
okay.
We will go on the record in the matter 26 CF16, State of Wisconsin versus Dean Sunderland. The state appears through District Attorney Kevin Schmidt in person. Mr. Sunderland appears in person with counsel Amber Sherwood. Mr. Ryan Reed does not need to appear here today. Mr. Sunderland is in custody, if I didn't say that. We're set today in this matter for a plea and sentencing hearing. I have received the waiver of a preliminary hearing and a plea questionnaire waiver of rights form. I believe that the offer is to plead to a misdemeanor. Is that correct?
That is correct, Your Honor.
The count 3 disorderly conduct.
Yes, that'd be for cost and time served.
Cost and time served. How many days has he sent?
He has set, I apologize. He has set 72 days, I believe.
Wow.
Is that correct? I could double check. That might have been for
I
his
don't
last
think
case.
so.
No, it could have been for his last case. I apologize, Your Honor.
Because I've only had a case with him since February 17th. That would be a lot of days.
He has been in custody since February 17th.
Like, wow, that's a lot of days in a month. Good point. All right, well, you're looking for that or calculating that. Mr. Sunderland, your attorney went over with you this document that's called a waiver of preliminary hearing. Is that correct?
Correct.
And she read it to you completely?
Yes, she did.
And you understand it?
I do.
And you signed it?
I did.
And do you understand that you're waiving it and that's forever?
Yes.
Anyone threaten you or promise you anything?
They did not.
You're just doing so voluntarily? All right. So I will find that you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and bind the matter over information.
Yeah, I can file an information.
All right. So not guilty pleas are going to be to count 1 and 2, and you're intending on pleading guilty to count 3, correct?
Correct, Your Honor.
All right. How many days?
37 days, Your Honor.
So on that plea questionnaire waiver of rights form, did your attorney also go over that document with you?
She did, Your Honor.
Read it thoroughly,
Yes.
word for word?
Word for word.
You understood everything?
I did.
You signed that document?
I did, Your Honor.
You're pleading guilty to that disorderly conduct. No one's threatened you or promised you anything?
They have not, Your Honor.
And you understand your constitutional rights?
I do, Your Honor.
Do you need me to go over those rights with you in any more detail?
I do not, Your Honor.
Do you understand that you're waiving and giving up those rights?
I do.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
I do, Your Honor.
Do you understand the state would have to prove on or around February 15th, 2026 in Burnett County, Wisconsin, in a public place, you engaged in indecent, abusive, unreasonably loud, or otherwise disorderly conduct, which tended to provoke a disturbance?
I do, Your Honor.
Do you understand the maximum possible penalty could be a fine of up to $1,000 or 90 days of incarceration or both?
I do, Your Honor.
Do you also understand that there is an agreement here for a time served and costs, but I don't have to follow that?
I do, Your Honor.
And do you understand that I could sentence you to that maximum penalty if I thought it was warranted?
I do, Your Honor.
Do you still wish to proceed and enter a guilty plea?
I do, Your Honor.
Are you admitting here today that in that public place you were acting either unreasonably loud or indecent or et cetera, and that it provoked a disturbance?
I do, Your Honor.
Ms. Sherwood, may the court use the probable cause section of the criminal complaint along with the statements made by your client to find a factual basis?
You may, Your Honor.
So no one threatened you or promised you anything?
They have not, Your Honor.
And did your attorney thoroughly go over the facts with you
She did, Your Honor.
and whether or not you had any defenses or any lack of defenses?
Correct.
Are you satisfied with her services?
I am, Your Honor.
Any questions for the court or for your attorney before I proceed?
I do not, Your Honor.
As to count 3, disorderly conduct, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 3. The other 2 counts will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Victims' rights compliance?
Yes, Your Honor.
All right. No input. Okay. All right, Mr. Schmidt, argument.
The victim did give some input. When we told her what this agreement be, she thought DC with time served for the amount of time he spent in custody. She thought that was appropriate. His conduct was disorderly. It was a negative in that it involved a child. I think the large number of days in jail he sat is sufficient for it. Thank you.
Thank you. Ms. Sherwood?
Yes, Your Honor, we're asking to follow the recommendation. Not only has the time spent in custody been very punitive, Mr. Sutherland has another court appearance on April 20th where he would like to get his affairs in order before that plea and sentence happen, or for the sentencing happens there. And he will be paying fines. Your Honor, we are asking you follow this recommendation.
All right. Mr. Sunderland, is there anything you want me to know, what you want to tell me? Because I think you've written me a couple times.
I have, Your Honor. I'd just like to say, I do apologize to my family. And at first I was quite resentful towards the situation, but the time I've served, I've been able to overcome that resentment and just hope that they'll forgive me one day in life. I do still love my family.
Okay. And the relation, was it your grandma?
My aunt.
Your aunt?
Yes.
Okay. So your aunt and then your nieces, that's what it was.
Correct.
Yeah. And so you had some time to think about it.
I have.
And if I'm remembering correctly, you have cases in St. Croix County that you're trying to resolve.
Correct, Your Honor.
So what kind of improvements and things are you going to do in your life? What are you looking at doing?
At some sort of AODA, Your Honor, treatment, establish some sort of community relevance more than what I have.
Okay. And so are you going to look at any type of like services, facilities or something? We don't have much here.
And I was thinking of the Salvation Army ARC program when I'm able to do that, or Teen Challenge or something in that matter.
I really hope that you do, Mr. Sunderland. You look like a nice young man. And I suppose suppose you're different when you're under the influence, even if it's just alcohol.
Correct.
But it's better to have you as a nice young man than somebody who can engage in this type of behavior, especially with your nieces. I don't know them, but I know teenagers because I have them, so they can be snotty and snappy and all of those things. But still, you're the one who's supposed to be showing them how to be and how to be good adults and members of the community. And so hopefully you're going to take time to think exactly about what you want to do and find a plan and actually do it, because I want to see you sober and I want to see you living a life and doing what you should be doing and need to do, like taking care of yourself, having a job, feeling good about yourself because of what you're doing and what you're providing to yourself and to others. So I'm really hoping that you're going to get a plan in place and you're going to be able to do that.
Thank you.
I think that based on this, 37 days in jail is enough. And so what I'm going to do is I'm only going to assess the $200 DNA surcharge. I'm waiving the court costs and fees. But I'm going to tell you right now, I'll be very blunt and very honest with you. I am harsh when it comes to collecting fines and fees and things, especially when I waive some of them. So I will give you the lowest of the low monthly payment that I do, which will be $25 a month, but I expect $25 a month. If you do not pay $25 a month, a warrant will be issued and you will be arrested and come to jail, and you may have to sit up to 6 months in jail. Okay, you need to make sure that you pay $25 a month. And I'm giving you this warning because I am a stickler when it comes to paying back, especially when I waive some of them. Okay, so it's not going to be a surprise if you get a warrant and you write to Judge Mogan, please, I can't pay this, I can't get a job. Figure it out. Okay?
Okay, got it.
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. The jail will make sure that they get that. You have the ability to request it be expunged through a written letter to the Department of Justice. Just do better, be better. especially with family. And I know sometimes it's hard with family, and we want to yell, we want to fight, but they're our family, and we should try and do the opposite of that. Yeah, 37 days of jail, time served. Good with that. Mr. Schmidt, what am I missing?
Nothing from me.
I apologize, Your Honor. He has another court fees with you. He was just wanted to, since he's been in custody now for 30 days, I told him I would help get that situated.
He has other court fees owed with me?
Yes,
Oh,
Your Honor.
And so do I have you set up on a different payment plan?
Correct.
And how much do I have you paying in there?
25 a month.
Okay, this can be added to it. But again, I am warning you that if you do not make your $25 a month payment, you're gonna get a warrant. And I don't take that I'm in custody in Polk County or Washburn County, or I've been in custody somewhere else. It's not my problem,
Okay.
okay?
Okay.
All right, thank you.
Thank you.
We are adjourned.
Thank you.
But are you gonna be in custody until, are you being transferred, is he being transferred to St. Croix, or is he released? You're released, so go to court. Don't get a warrant in St. Croix County. Okay?
Or in Pierce.
Or in any county, ever, okay? I'm tired of it. Everything has asked me to verify things twice now.
Okay. Yep. I couldn't.
Wait, did you catch that? He just pled guilty, but said he's not satisfied with his own lawyer. That's a huge red flag, because legally, that could open the door to appeals, claims of ineffective counsel, or even questions about whether this plea was truly voluntary.
Yeah, I couldn't. No, those are separate ones, not part of that. So that one. Oh. For the search by names. Partnership, so she just assigned to the existing partnership to go for a sum of money. Money's in your trust? Yes. It's back in 2022.
All right, are we ready? We will go on the record in the matter 25 CV03. 21 PR02 in the estate of Harold Johnson. Appearances are, we do have appearing in person, personal representative Eugene Harrington. We have counsel Ryan Benson. We also have some of the heirs who are appearing in person. We have Michael Johnson and we have Susan Johnson Rohr.
I think Michael's on the phone. Steven's
sorry,
here.
Michael is on the phone. Stephen, thank you. Stephen Johnson is in person. Michael Johnson is on the telephone. We also have Peggy Johnson's personal representative appearing, and we have Angel. What's your last name, Angel?
Angel Jones, also personal rep, Peggy Johnson Estate.
All right, thank you. And also a personal representative of Peggy Johnson Estate. We're set here today in this matter for the final hearing This case is very old, and it's taken a while to get here. Mr. Benson, do you want to please update the court?
Yeah, thank you, Your Honor. So we had filed an amended inventory back in July of 2025, and then then there's a certificate of or affidavit of mailing on file that went out to the heirs. And then we did file the final account and the proposed order to close and petition to close in early January of this year, and an affidavit of mailings on file with that. This morning, I received an email from Stephen Johnson objecting to the amended inventory. And obviously, I have not had time to look at that in total and determine what, if any, concerns can be addressed here today on that.
Address it right now. Mr. Stephen Johnson, get on up here and have a little seat at the other table. He's had concerns since, I think, day one, Mr. Benson.
That's true. I just don't know how to answer some of his questions here today without a thorough look at all the documents.
All right, so he has issues, he has concerns, and he's going to make light of them to the court. What else?
Other than that, I don't believe any of the other heirs have any objections and would love to see this probate closed. The only other issue to deal with is the accountants waiting until the court approves the final account before doing the final fiduciary return. So I would anticipate once the court approves the documents that we'd be able to disperse in about 30 days after that date.
All right, Mr. Harrington, as personal representative, do you have anything, any input, anything you want to update me on?
I do. Let me choose my words.
Please do. Can you please turn the microphone?
You appointed me in this estate more than 2 years ago. And quite frankly, if I had known the mess, I would have declined.
I apologize, I did not realize the extent of this either.
I'm not sure what's going on. I had a brief conversation with Stephen this afternoon, and he told me that there's some assets missing. Like Mr. Benson, frankly, I didn't look at my email until about 11:30 today and printed this stuff off after that. So I haven't had an opportunity to talk to Mr. Benson about it. I note that the parcels of real estate that Stephen is concerned about were all Minnesota property. And there was significant litigation in Minnesota over the properties and some limited partnerships and other things. And frankly, I thought that was all done. I know that within the last year or so, or 9 months, I signed some conveyance documents, some tax returns, and authorized Mr. Benson to deposit $100,000 or more into his attorney's trust account. And quite frankly, I thought this was resolved. Other than that, I'm concerned that this case, Sue told me that her dad's been deceased 6 years, and this estate isn't done yet.
We've been fighting over Christmas ornaments and things, and bookshelves, and all kinds of little nicky-nacky things.
If I had known that's what this was about, I would have politely declined.
The court had already decided on that.
Yeah,
so
all right.
I am just as baffled as you are to be hit with things today, and I will gladly hear them. Today is for the court to approve the final accounting, and that's what it was set for, and that is exactly what this court intends to do.
Then I'll cut my comments off because might waste your time. I don't want to do that.
You are no waste of time, Mr. Harrington. I would love to hear everything that you would like me to know, candidly, but choosing your words, because that is That is my job to know about all of these
Yes, it
things.
is.
So if you have more to say, I'm
I'll
very here.
refrain. Get to Mr. Johnson, please.
I will, thank you. All right, Mr. Johnson, you have issues, and you have issues that are just being brought to people's attention on the eve of the last day for the court to approve the final accounting. And you have had ample notice of years and years and years. And I'm even talking with the resolution of the Minnesota properties, because that's what we were waiting on. That was what was hinging this case from resolving, because I already addressed the Christmas ornaments. I already addressed the book account or the bookshelves and all of those things years ago. And we already have Miss Peggy Johnson, who is unfortunately passed away, who is the personal representative to begin with in this case. And so you wait until the very eve of the court approving a final accounting when things have been filed. We had all ample notice from January 5th, 2026, from the filing date and time from Mr. Benson, plus the multiple hearings that we have had. So please enlighten the court and let me know what your issues are.
Okay. I want to say thanks to Ryan because he helped me last week resolve something. And that was where there was always an L&H Farm LLP. Okay. Knew about that. I was confused about the things because there happened to be 6 parcels there and I wasn't sure what was what, you know? And so I got that resolved. Okay. It was hard to do because you had to go back and look at the information in Pine County as far as they were split up subsequently. So it was hard to see what happened back in 2020 and 2024. Okay. So I got that resolved with Ryan's help. When I was doing that, then I came across another L&H Development LLP. Okay. And I didn't see that anywhere and I didn't know what that was. And I think what that was where they held their mining operations and all their equipment. And so I asked Ryan, do you know anything about this? And then he sent me a dissolution in 2017. But then I noticed that in 2018, they were still doing transactions. But I don't have an issue with that. But it's odd that they were still conducting business in 2018 when they wrapped it up in 2017.
Could have been violating the law.
Yeah, I don't know. So that I'm fine with. I'm fine with all that. All the Whitetail Ranch stuff, I don't even need to talk about that. But what I did actually is I looked at the numbers just at a very high level and I go, this doesn't add up on a very high level because the original inventory was $292,394. Okay, that's what Peggy came up with. Then the amended inventory was $349,250. I added up everything and I came up with $405,470.93. What I did was I looked at the original inventory list and I said, okay, of these items, which ones are on the amended inventory list? And I came up with 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 items missing, okay? From the original that weren't on the amended. And these are items that were sold and we have record of them being paid for and stuff like that. So that money exists somewhere. So then what I did is I looked at the amended inventory and seen what was added to it from the original inventory, you know, new stuff like the coin collection. And I came up with 1, 2, 3, 4, 5, 6, 7, 8, 9 things, and that totaled 18,000. The original inventory that I just talked about, the missing from that in the subsequent one was $6,000. But then what I did is I went through it because we got better prices on some of these on the amended inventory than what was, meaning we made more money from the amended inventory listed to there. And that total was for Whitetail Ranch LLP, we got an additional $32,364.69. For L&H Farm LLP, the original was $63,050. and we ended up getting 197,000. So it's an additional 46,000. Pine 01, the original was 9,800. The amended was 12,467. So that we got an extra $2,667. Then for HMS LLP, the original was 12,350. The amended, we got $14,196.08 for a positive difference of $1,846.08. So the actual totals of all that, the 32,000, 46,000, 2,000, 1,800, 1,500, is an additional $55,920.14 that is, we made more money than we planned to on the amended return. The amended return said we get this much money, we got an additional $55,000 extra because we sold them for more than was on the amended return. And then some stuff I couldn't figure out because like firearms, the original was $23,205. The amended was $20,000, so a difference of $2,987. So, but I think that was all. I couldn't find out what Chad paid $17,813. I paid $250. I believe Peggy paid $700. And then there were some other guns there that Sue, Mick, Matt, and additional Peggy's that might have made up that difference. So I'm not saying there's a difference. I don't have the information to determine whether we got money in there and it's not recorded.
Okay.
And
so
then
you're saying you think there's something going on, or you think that there could be discrepancies. You don't know. You don't have anything to back it up.
We're within $3,000 of firearms being correct. But I can't, I don't have the information to resolve it because I don't have any receipts. I don't know. So then the antiques, original was $2,000. The amended was $2,285. So we made additional $285 on that. So then you'll look at all that stuff and
you're gonna have to speed it up a little bit.
Okay, I'm pretty much done. I mean, all that stuff is, you look.
37 days. A small sentence for a case involving a child. But here's the real question. Did justice actually get served? Or was this just the fastest way to close a complicated, uncomfortable case?